Good evening and welcome to RFL. I'm Richard French. Now, for the first time since his trial started nearly 3 weeks ago, we heard from Derek Chauvin in open court today.
We've had this conversation repeatedly, correct?
Correct.
I have repeatedly advised you that this is your decision and your decision alone, right?
Correct.
I have advised you, and we have gone back and forth on the matter, would be kind of an understatement, right?
Yes, it is.
But after a lengthy meeting last night, we had some further discussion, agreed?
Correct.
And have you made a decision today whether you intend to testify or whether you intend to invoke your Fifth Amendment privilege?
I will invoke my Fifth Amendment privilege today.
Soon after, Chauvin confirmed that he would not testify. Both sides rested their cases. Closing arguments set to begin on Monday. Then the jury will start deliberating. But before they wrapped up in court today, carbon monoxide was the major issue the day after a defense witness, who's a former medical examiner, had this to say on stand.
The toxicology, the fentanyl and methamphetamine, there is exposure to a vehicle exhaust, so potentially carbon monoxide poisoning, or at least an effect from increased carbon monoxide in his bloodstream, and paraganglionoma, or the other natural disease process that he has. So all of those combined to cause Mr. Floyd's death.
Today, the prosecution got to recall a witness to respond to what Dr. Fowler said, and that witness, renowned pulmonologist Dr. Martin Tobin.
2% of carboxyhemoglobin is within the normal range. You and I have levels of carboxyhemoglobin of somewhere between 0 and 3.
And so in other words, as to the statement that his carboxyhemoglobin could have increased by 10 to 18%, in your view, that's not possible.
It's simply wrong.
Now, there was some drama surrounding Dr. Tobin's testimony because the judge said he'd declare a mistrial if the prosecution even mentioned tests showing that carbon monoxide levels in Floyd's blood were normal, because that would be new evidence that had not previously been introduced. Now, besides the cause of death, another major point was the use of force and whether or not Chauvin followed police procedures. Now, we heard from a parade of police officers who said what Chauvin did was totally inappropriate, but the defense had witnesses who disagreed. Take a listen to both sides, starting with the chief of police in Minneapolis.
To continue to apply that level of force to a person proned out, handcuffed behind their back, that in no way, shape, or form is anything that is by policy, is not part of our training, and it is certainly not part of our ethics or our values.
I felt that Officer Chauvin's interactions with Mr. Floyd were following his training, following current practices in policing, and were objectively reasonable.
Let's bring in our first guest to discuss. Tom Heffelfinger. He's an attorney in private practice in Minnesota. He's also a former assistant Hennepin County attorney and also a former federal prosecutor. Perfect person to get his perspective on what we've seen. To the layperson, Tom, the prosecution really laid out a compelling case between the video that we saw time and again, the witnesses on scene, and the experts. Now that we've heard both sides, if you were Officer Chauvin, would you be concerned?
Well, it should be, but the defense also accomplished what they wanted to do, which is to establish some doubt in some of those very same areas. I agree with you, Richard. The prosecution was compelling in 3 areas: people on the street, the videos, and number 2, the use of force experts, and number 3, the health issues. But one of the things that Chauvin and Mr. Nelson had to do is, in those areas of strength, identify some areas where there could be some doubt. Remember, they don't have to prove his innocence, but if there's reasonable doubt, that is what the defense is looking for.
Help us out. Did the prosecution screw up here today in that on the carbon monoxide issue, apparently they had tests that would, empirically refute what we had heard the day before, but there was admissibility issues since they hadn't brought them up prior. I know on cross, as we just played here, they said no. The public said no, carbon monoxide was below the 3% level without going to the specific report. Did prosecution do enough, or will they regret they didn't have their ducks in a row?
They were chastised to some degree by the judge for not having worked with the medical examiner to identify and fully disclose those carbon monoxide tests. However, the prosecution did something very well and very clever. They brought back Mr. Tobin, Professor Tobin, to talk about this issue of carbon dioxide in the blood. And his testimony essentially rebutted the testimony of the defense medical examiner. And quite frankly, because Dr. Tobin was such a compelling witness, having him be the last witness that the jury sees in this trial is probably the best thing that the prosecution could do.
We played the clip, as you heard, of Officer Chauvin confirming for the judge that he would not be testifying, he'd be invoking his fifth. But maybe I'm reading into it. It certainly seemed that him and his attorney, Mr. Nelson, had a lot of conversations about this. In the end, it would have potentially opened Pandora's box, but given the mountain of evidence and the mountain of people, including the chief of police, the top pulmonologist, et cetera, do you think it was a close call to put Chauvin on the stand for almost nothing to lose?
Well, first of all, it's his choice and his choice alone. His lawyer would have made some very clear recommendations, and Chauvin was free to take those recommendations or not. I don't know what Eric Nelson recommended, but I do know that one of the things that they started talking about from the very beginning of this trial was that lawyer and that defendant were talking about, will you testify? And I can almost guarantee you that the last thing that they talked about before they parted ways last evening was, are you sure you still want to assert your Fifth Amendment privilege? So this is a process, not a decision. It's a process that starts at the beginning of the trial and it ends the night before you have to announce that you want to take the fifth. And it requires the input from the lawyer as to how good the case is going in for the defense, as well as Mr. Chauvin's gut instincts.
Let me, speaking of gut instincts, let me ask you your gut instincts on this. Jurors are human beings. I know they've been counseled by the judge to not look at any external information or reporting on this, but when they go home, somebody's going to tell them, if they don't already, that 10 miles from their courtroom, what happened to Daunte Wright and the surrounding circumstances. How much external pressures or concerns about, depending how the verdict goes, the ramifications, do you think are realistically weighing on jurors' minds?
Well, that's why Eric Nelson asked the court to sequester all the jurors on the Chauvin case so that they couldn't hear the overwhelming volume of publicity that the Wright tragedy is getting. This is very similar to what happened early in this trial when the Minneapolis City Council publicly announced a large settlement with George Floyd's family. And that almost caused a mistrial there. In this case, the judge, I believe, is relying on the fact that he has instructed the jurors not to watch television, and he's relying on the fact that they will follow his instructions. But I certainly understand why the defense is very worried that jurors are watching that television reporting and making decisions on the Chauvin case based on, in part, on what they're seeing in regard to Mr. Wright.
Is it too late, Tom, for a plea here? And I'm trying to put myself in Nelson's shoes. And if anything, even for the layperson watching this, you can see the difference in lack of resources, by the way, in terms of what the prosecution's brought to bear and Nelson seemingly being a one-man show. But nonetheless, there's 3 charges we talked about last time, the manslaughter charge and the 2 murder charges, second and third degree. My point is, you know, is it basically now in the hands of the jury, or if you're Nelson, do you basically potentially try and see if you can get a deal?
It is never too late until the jury comes back with a verdict for a defendant and his lawyer and the prosecution to discuss settlement. I've seen cases where the jury is out and the defendant decides to enter a plea before they come back with a verdict. So it's not too late. It's too late after the verdict comes in, but not before that.
Would you consider that if you were Mr. Nelson right now, given what's played out in the last 3 weeks?
No, I wouldn't. I think that they have done a very good job of creating enough evidence where to support doubt. That's what it's all about. Have they given the jury enough information on which somebody who's doubtful of what they're hearing from the prosecution just says, I can't go with it? No, and at this point also, I don't know that it would have a plea agreement at this point would probably have minimal impact on whatever sentencing was imposed by the judge.
So last question, Tom. For both sides, how would you close? And as the prosecution and defense get ready for that closing, who do you think is confident that they're going to secure the verdict that they're hoping for?
Well, the entire prosecution team, I think, is very confident. And if I were doing a final argument for them, I'd be focusing as much as I could on the elements of the 3 charges that are pending against Mr. Chauvin. They're complicated charges. For example, what does depraved mind mean? That's a second-degree murder. That's the third-degree murder. The culpable negligence, that's the manslaughter. So I think they have to put a lot of time and effort into telling the jury what the charges are. From the defense side, I would be hammering away at the jury instructions on requiring the prosecution to prove the case beyond a reasonable doubt, and I'd be going through a laundry list of doubts that a reasonable person should have about the prosecution case. So those are the 2 hearts of the case for the prosecution and the defense, is the elements of the charges and reasonable doubt.
Tom, thank you as always. I really appreciate the perspective.
My pleasure.
All right, folks, when we come back, I want to pivot to the other top story today, and it got lost a little bit in the news cycle, but I think it's really important. The Capitol Hill riot. Tomorrow will mark 100 days since Trump supporters stormed the Capitol, and today on the Hill, we got new details about the police response and how unprepared they were for what happened, even though it turns out there were ample warnings. We've got the very latest for you after the break.